She believed she had him trapped. Judge Amy Coney Barrett gazed across the courtroom at the guy in tattered jeans and a scuffed leather jacket, confident this would be a walkthrough. The legendary rock star had entered her federal courtroom, believing his fame would insulate him. But what transpired over the next 30 minutes left everyone aghast, even the judge herself. If you think that respect is achieved through knowledge and not merely position, do not forget to click on that like button and subscribe to our channel, because you are going to be reminded why you must never judge a book by its cover or by its job. Bruce Springsteen sat silently at the defense table, his worn hands clasped in front of him. The press had made this out to be a mere case of celebrity selfishness, but they did not know what was going to happen in Judge Barrett's court that Tuesday morning in Newark, New Jersey. The lawsuit had begun 6 months prior, when Springsteen's property management firm was sued by a group of tenants from one of the low-income housing buildings he owned in Asbury Park. The renters alleged dangerous living conditions, unauthorized rent increases, and violations of federal housing code. The press was merciless. Tabloids yammered about the rock star millionaire taking advantage of the poor, the same poor people his music had been fighting for all these years. Judge Amy Coney Barrett had been put on the case. She was 52 years of age and well known for having a sharp legal brain, as well as being a no-nonsense judge for celebrity cases. She had built her career on being as rough on famous defendants as on ordinary people, sometimes tougher, in order to illustrate the idea of equal justice under law. The courtroom was filled that morning. The gallery was filled with reporters, the hallway outside with cameras, and every available seat taken by legal observers. It was the sort of high-profile case that had the potential to make careers and break reputation. Barrett stepped into the courtroom with her familiar assertive walk. She had prepared for weeks for this case, poring over every aspect of housing law and tenant writing. She was ready to demonstrate that Bruce Springsteen, no matter how famous and wealthy, would be held accountable for his behavior as any other landlord. Springsteen's lawyers were 3 high-priced attorneys from a high-flying Manhattan law firm. They sat next to him in their fitted suits, briefcases full of motions and legal pleading. To everyone looking on, it appeared to be the classic scenario of rich celebrity employing expensive attorneys to avoid prosecution. But something did not quite feel right about Springsteen himself. As his attorneys huddled together and rustled papers, he sat quietly reading out of a thick textbook of law, making the occasional annotation in the margin. When he was questioned by journalists outside the courthouse, he responded in exceptional detail and specificity, well beyond what most celebrities provided in court cases. The trial commenced with the plaintiff's lawyer making their case. Margaret Chen, a passionate advocate for housing rights, painted a damning portrait of neglect and abuse. She showed the jury pictures of leaking roofs, dysfunctional heating, and hazardous electrical wires. She heard testimony from older tenants who had lived in terror of being evicted following complaints about living conditions. Judge Barrett nodded attentively, her face darkening each bit of testimony. When Chen concluded, the judge addressed Springsteen's attorneys with thinly veiled disdain. "Mr. Davidson," she spoke to the lead attorney, "I should hope you have a better defense for your client's behavior than we've heard thus far. These conditions are obviously not acceptable." Davidson, the lead counsel, rose and started what sounded like a typical celebrity defense. He discussed mismanagement by property management firms, lack of direct supervision, and his client's hectic touring schedule denying adequate attention to business issues. Judge Barrett's patience visibly thinned. "Mr. Davidson, your client owns the property. The buck stops here. Are you saying to this court that Mr. Springsteen had no knowledge whatsoever of these conditions?" "Your Honor, my client has been preoccupied with his artistic career, and excuse me." The voice was at the defendant's table. Bruce Springsteen had risen to his feet, hand politely raised. "Your Honor, might I speak to the court directly?" Barrett's eyebrows flickered. It was not typical for defendants to testify on their own behalf when they had counsel representing them, particularly on complicated civil cases. Davidson's face appeared shocked, and he objected at once. "Your Honor, my client won't have to." Mr. Davidson, Barrett cut in. "Your client has a right to be heard. Mr. Springsteen, you can continue, but I advise you that anything you say can and will be used in this proceeding." Springsteen nodded and proceeded to the podium. He did not seem like the average defendant, There was no fidgeting, no avoidance in his demeanor. Rather, he addressed the court with quiet assurance. Your Honor, I would like to start by addressing the valid complaints of the tenants. Their grievances are genuine and their pain is genuine, but I think there are significant facts that have not been brought before this court. Judge Barrett leaned forward, taken aback by his bluntness. Continue. The houses in question were acquired by my company in 2019 through a complicated foreclosure procedure. When we bought them, we found that the former owner had been under a federal consent decree for 15 years of systemic housing violation. Barrett's demeanor shifted slightly. This degree of legal specificity was not to be expected from a rock musician. Springsteen proceeded under Section 8 of the Housing Act of 1937, as amended, and more particularly the housing quality standards that are set out in 24 CFR 982.41. We had to put these properties into compliance within a certain time frame while continuing to provide affordable housing for current tenants. The judge flinched. She had not anticipated an exact reference to federal housing laws. In addition, Springsteen replied, referring to his notes, that the Hills v. Goro case set the precedent that housing providers in a case such as ours have a positive obligation to correct past discrimination without causing tenant displacement. Margaret Chen, counsel for the plaintiff, sat up quickly from her notes. Judge Barrett's expression indicated mounting surprise as Springsteen cited a seminal Supreme Court housing case with precise accuracy. Mr. Springsteen, Barrett replied slowly, are you reading from prepared notes? No, Your Honor. I'm testifying in my knowledge of housing law, which I've been studying intensively for the last 4 years. Davidson, Springsteen's own lawyer, seemed shocked, like everyone else in the courtroom. Springsteen reached into his jacket pocket and produced a folder. Your Honor, I'd like to introduce evidence that hasn't been part of the plaintiff's case. May I come up? Barrett nodded, still trying to believe what she was hearing. Springsteen presented her with a thick folder of documents. These are work orders, contracts, and reports of inspections indicating a methodical program of renovations that was implemented immediately upon our assuming ownership. The property improvements investment has been $2.8 million over a 3-year period. Judge Barrett scanned through the paper. They were carefully labeled with legal tabs and cross-references that indicated sophisticated knowledge of evidence presentation. Your Honor, Springsteen went on, the attorney for the plaintiff offered pictures of deplorable condition, but didn't show the dates when said pictures were taken. I think the court will see that the majority were taken during the initial inspection period in 2019 prior to the renovation. Chen sprang to her feet. Objection, Your Honor. The defendant is making unfounded accusations regarding evidence. Mr. Barrett. Springsteen responded, can you validate this statement? Yes, Your Honor. Springsteen got up and returned with another folder. These are technical reports from the digital files produced in discovery. The EKF data indicates creation dates for the photos which I had verified independently through a forensic digital analyst. The courtroom was silent. Barrett read over the technical reports in increasing wonder. The evidence was exhaustively and professionally examined, but Springsteen was not yet done. Your Honor, I would like to also refer to the accusation of unfair rent hike. According to New Jersey Rent Stabilization Statute, NJSA 24284.3, landlords can raise rents to pay for capital improvements that make living in the building more habitable, as long as due notice is provided and the work is documented. He offered a second batch of paper. These were the improvement timetables, cost breakdowns, and tenant notices for each rent in. Each raise was calculated under the law and voted on by the local Rent Control Commission. Judge Barrett examined the document. Her initial confidence was starting to falter. This was not the celebrity defendant she had anticipated. In addition, Springsteen stated, with respect to the charge of unsafe condition, I'd like to call the court's attention to Section 27205 of the New York City Housing Maintenance Code, which has been used as a model by municipalities in New Jersey. Not only do our properties comply with these requirements, we do them better in many areas. He presented certificates of inspection from 3 separate housing authorities, all of which had compliance ratings greater than minimal standard. Kala virtuari jidshirch intenti, intenti urto nierd %. Margaret Chen grew more and more uneasy as her allegedly watertight case started to develop major cracks. Judge Barrett placed the papers down on her desk and stared at Springsteen. Mr. Springsteen, I must inquire, where did you learn all this legal information? Springsteen grinned for the first time that day. Your Honor, once I bought these properties and heard about the housing issues in my neighborhood, I knew I had to know the law if I was ever going to be able to make a difference. I took the part-time evening program at Rutgers Law School 4 years ago. I just graduated last month. The courtroom hummed with whispers. Judge Barrett's mouth fell open in shock. You have a law degree? Yes, Your Honor. I majored in housing and poverty law. My thesis was federal housing policy intersecting local community development. I graduated with a 3.8 GPA and continued to tour and record. Davidson, representing himself, appeared as if he'd been hit by lightning. Judge Barrett rolled her head slowly. Mr. Springsteen, why was this information not brought forward by your legal team earlier? Springsteen looked at his high-priced legal team, then at the judge. Your Honor, I respectfully believe my counsel thought that being a celebrity client meant you'd worry about public relations instead of legal groundwork. They told me to remain silent and let them work it out. The judge looked at Davidson sternly. Mr. Davidson, is this correct? Davidson stood uncomfortably. Your Honor, we believed a classic defense approach would work best, hiding from everyone the reality that your client is constitutionally entitled to defend himself and has documentary proof on his side. Barrett's tone had a cutting edge. Something happened that left everyone in the courtroom shocked. Judge Barrett ordered a short recess to scrutinize all the new evidence. When court reconvened, her whole attitude was different. Having examined the evidence provided by Mr. Springsteen, she started. This court recognizes serious issues with the case of the plaintiff. The photographic proof seems to be old and possibly deceptive. The allegations of rent hike are disputed by official approvals of the municipality. Above all, the improvement efforts documented reveal a trend of good ownership and not neglect. Margaret Chen attempted to interrupt, but Barrett went on. But this case has uncovered something much more sinister than housing code violation. Mr. Davidson, your defense of your client has been so subpar that it borders on malpractice. You did not introduce key evidence. You distorted your client's credentials. You counseled him to keep his mouth shut when he was the most informed man in this courtroom about the applicable law. Davidson's face blanched. Judge Barrett turned back to Springsteen. Mr. Springsteen, I owe you an apology. I entered this courtroom with assumptions about celebrity defendants. I thought you were hiring high-priced lawyers to duck responsibility for legitimate housing code violation. Instead, I find that you're likely better qualified to argue housing law than half of the lawyers who stand before me. The crowded courtroom was utterly silent. In addition, Barrett went on. Your strategy for these properties embodies just the kind of responsible ownership that housing advocates have been calling for decades. You didn't just fix problems. You learned the law in order to repair them rightly. She raised her gavel, then hesitated. Mr. Springsteen, I have a strange favor to ask. With your credentials and your apparent dedication to housing justice, would you be willing to serve as a special advisor to this court on housing law cases? We encounter too many landlords who neglect their duties and too many tenants who are unaware of their rights. Springsteen stood up slowly. Your Honor, I'd be glad to assist in any manner in which I can. Judge Barrett smiled at last that day. Good. Now, as to this case, I'm dismissing all of the charges against Mr. Springsteen. The evidence unequivocally demonstrates due ownership and legal compliance. I'm nevertheless directing the plaintiff's lawyer to refund any fees garnered from the tenants, because it seems that this case was brought about without proper investigation. Margaret Chen had a chance to object, but Barrett interrupted her. Miss Chen, you were supposed to confirm your evidence prior to filing. Your inability to check those photographs' dates and to conduct investigations on the improvement efforts amounts to unpreparedness. This court is not going to be utilized for publicity-seeking lawsuits predicated on incomplete data. The media section of the courtroom hummed with activity as reporters typed furiously on their phones and laptops. But Judge Barrett wasn't done. She addressed Springsteen's legal team. Mr. Davidson, I'm suggesting to the State Bar Association that they examine your conduct in this case. Your client arrived at court better prepared than his own lawyers. That's not right, Davidson concluded. his papers trembling in his hand, clearly realizing that his reputation had been irreparably harmed. The fallout from the hearing spilled far outside the Newark courthouse. In a matter of hours, news sources around the nation were writing about the stunning turnaround. The coverage wasn't simply about a star winning a court case. It was about the ability of preparation, the risk of assumptions, and the necessity of peering beneath surface appearances. Legal commentators opined on TV news shows, commending Springsteen's extensive preparation and faulting both the plaintiff's lawyer for lack of investigation and the defense team for underestimating their own client. But the strongest responses were from average citizens who saw something motivational in the tale. Social media was full of comments from fans who were inspired to work toward their own educational aspirations no matter their age or background. A retired Ohio factory worker wrote, "If Bruce Springsteen can attend law school at age 60, I can complete the college degree I began 40 years ago." A Texas single mother wrote, "This indicates that learning doesn't cease. I am enrolling in night classes next semester." The article struck a chord particularly with working-class Americans who had listened to Springsteen's songs of dignity, hard work, and struggling for what is right since they were kids. Here was evidence that their idol practiced what he preached. 3 weeks later, Judge Barrett summoned Springsteen to talk about his advisory role. What they discussed uncovered more of his dedication to housing justice. "Bruce," she said, addressing him by his first name for the first time, "I've been mulling over your case. You could have brought in investigators to ferret out the same evidence you did. You could have left the legal research to your lawyer. So why did you attend law school yourself?" Springsteen's response picked up on the spirit of why the narrative had resonated with so many. "Judge Barrett, I came to understand years ago that composing songs about struggles faced by working-class people wasn't sufficient. If I truly wanted to make a difference, I had to grasp the structures that produce those struggles. If you don't know how justice is supposed to work, you can't effectively combat injustice." He broke off, then went on. "Too many in my job presume that problems can be fixed by cutting checks or giving speeches. But change needs knowledge. It needs work, not only rhetoric." During the months that followed, Springsteen's advisory efforts on behalf of the court resulted in dramatic improvements in the management of housing cases. He assisted in creating a mediation program that settled disputes prior to them going to trial, conserving time and money for both tenants and landlord. He also created a law clinic that offered free housing law education for both renters and property owners, enabling them to learn about their rights and obligations before issues arose. The effects were felt far beyond housing law. Law schools across the nation saw higher enrollment in their part-time and evening programs as many students cited Springsteen's example as motivation. The plaintiff's attorney Margaret Chen, who had initiated the initial case, later publicly apologized for her poor preparation. She started new procedures in her practice to investigate comprehensively before filing suit. David Davidson, Springsteen's initial lawyer, was disciplined by the state bar, but drew on the experience to improve his own practice, dedicating more time to careful preparation and less to shepherding celebrity clients. Judge Amy Coney Barrett also looked back at the case in interview, referring to it as one of the most instructive experiences of her time on the bench. "I learned that day that expertise can arise unexpectedly," she explained. "Bruce taught me that you never judge someone's ability by what they do for a living or what they project outward." Some of the greatest legal minds I've ever met have been individuals who converted from other professions into law with practical experience that book learning can't offer. The case was a classroom example in law schools employed to demonstrate the importance of adequate preparation, the hazards of assumption, and the benefits of client cooperation in legal defense. But most enduring of all was the reminder that learning and development never have to set any one age or phase of life. Springsteen's choice to seek legal education in his challenged many thousands of individuals into pushing themselves intellectually no matter their situation. The last lesson was respect and dignity. Judge Barrett had first viewed Springsteen as a self-indulgent celebrity to shirk responsibility. Springsteen might have regarded the tense grievance as annoyance to be dealt with by costly attorneys. Both of them, however, learned to look past appearance to discover truth and justice. It became a legend because it was something people wished to believe, that hard work and true preparation continued, that justice can triumph when people do their research. and that you're never too old to learn something new and make a difference in the world. If this video made you want to never judge a book by its cover or learn no matter how old you are, be sure to give us a like and subscribe to our channel. We have stories that remind us of the things that really make a difference. Respect, preparation, and the fearlessness to continue learning and developing ourselves throughout our lives. What did you think of Judge Barrett's change in this case? Tell us in the comments below.